Spanish, soy 100% gringo, pero hablo un poquito de español. Quiero hacer inglés mejor, pero... Yeah, thank you. My name is Stivers. I own the Probate Law Firm. Our main office is in Brickell. We do everything probate. So I don't do title, I don't do real estate, I don't do evictions, landlord tenant, any of that. So strictly probate. So I started doing this presentation a couple months ago because I realized there were a lot of realtors who are finding probate listings, but they're not really sure what probate is. So this course is about 45 minutes or so. Is really just to teach you guys a little bit about probate, what it is, how you can market for probate properties, hopefully find probate listings, and then when you go and find a probate listing, can you go to a listing presentation, how you can kind of stand out from your competition to try to get the actual listing. But I always like to kind of, just know who we have in the room. So maybe we can go around real quick, just like 10 seconds each, just state your name, how long you've been a realtor, and then if you ever come across a probate listing, either on the buyer side, personal side, and what that experience was like. Front and center.
Mi nombre es William.
Okay.
Llevo una semana en real estate.
Nice. Okay.
My name is Maria Elena Garcia. I
Long time. All right.
in property, real estate, 25 years.
Okay. Okay. Any probate properties?
Yes, I am a lawyer in Venezuela. I
Okay.
have a domain where legal office.
Okay. Cool. Thank you.
I've also been a realtor for over 25 years, but I haven't
Never dealt with probate? Okay.
Hi, how are you?
Good.
My name is Maria, and I just have my license 3 months ago.
All right. Very good.
I'm a lawyer in my country, but now I'm super excited with real estate course.
Awesome. Okay. Cool.
Okay, I'm Patricia Suarez. I've been in real estate for the last 15 years, and I have never had a probate. I don't even know what
What it
truly
is.
means.
Perfect.
That's
All
why
right.
I'm here.
Perfect.
Join the club again. I'm the new one.
Brand new.
Yes.
Okay.
And my
Welcome.
name is Mariana.
Okay. Nice to meet you. I'll go. Sir.
Yeah, my name is Leo. I have a couple of months in real estate, and I never had any probate and property.
All right. Cool.
Mi nombre es Rubio Linda, tengo 4 años de real estate. Tuve un caso con probate, pero al final no se dio, pero más o menos supe de qué trataba, de cuánto tardaba el proceso.
Okay.
Hola, mi nombre es Loredana Caruana, tengo 5 años en mi negocio y no he tenido ninguna.
Okay. Great. Thank you.
My name is Catherine Gutierrez. I've been for 1 year and a half, and I don't have any probate experience yet.
Okay. Yes.
My name is Carolina Howard. I'm new here in this office. I have the licenses in 2010, since 10 years, 10 years. And I don't have any experience with property.
Okay. Great. Great.
My name is Janine. I've been a realtor for almost 10 years. And no, I have never been in any case with a probate.
Okay.
My name is Alejandra. I've been a realtor for like over a year. I don't really remember. I know I never had the pleasure to have a property.
Okay. Great.
My name is Daniel Frick. I've had my license for 3 weeks.
Wow. All right. Brand new office. Yes. We go in the back.
Hi, my name is Sally Latico. I've been a realtor for the last 2 years, and no experience.
Okay. Awesome. Cool.
I'm Lily Klinar. I have my license since 2013. I've worked with probates, but I haven't closed one yet.
Okay.
So
Gotcha.
I tried to get a lot of listings, and but nothing that has been successful so far.
Okay. Awesome. Well, it's a brand new group, so that's awesome. So I will try to make this as, it's not, the most exciting topic in the world. So I'm going to try to make it, somewhat interesting and make it relevant for you all as much as possible. Like I said, this is not going to teach you everything there is to know about working with a potential buyer, potential seller, you can help them go through the process. But I'm gonna try to keep it very, very basic since a lot of you all are brand new and haven't had any probate experience before. Just so that there are a bunch of handouts, we're gonna go through some of them, so if you don't have handouts, they're on the back table back there. So to kind of start, so what is probate? Probate is a legal process. It involves courts, it involves judges, it involves attorneys, and it happens after somebody has died. So it's kind of a sad, dark thing, but basically, in order for there to be a probate, someone has had to have passed away, someone has died. So the example I always use is, let's say George owned a house, okay? Now George has died. It has to go through the courts before the courts are going to say, all right, now George's family can sell the property. So you're trying to get clean title. George passed away, he owns his house, now George has died, and at the end, the judge is going to say, okay, now let's just say George's children are the owner of the property. See a lot of blank stares.
That's when they die without a will, right?
Even if they have a will.
Even if they have a will.
And we'll talk about wills. But yeah, so basically, someone has passed away, and now the courts have to say who's going to get what of everything that they own. Another common term that we'll use is estate, so E-S-T-A-T-E, which basically just means everything that George had, all of his house, his boat, his car, his jewelry, his clothing, everything like that, that was all George's. Now that George has died, we call all of that his estate. So in probate, when we're doing a probate, we would say the estate of George. And that refers to everything that George had now that he's passed away. All right, last will and testament, you mentioned it. So a will, has everyone ever heard of a will? Know what a will is? So a will basically is a piece of paper that you can write on. There's certain requirements, but I could say, okay, I leave my house to my brother. And then when I die, my brother would take that will to show the court that, I left everything to him. So a will is basically just a piece of paper, a legal document, saying who I want to get my stuff after I pass away.
It must be registered, or?
It's not registered. It has to be, the only really requirements are that you have to sign it and there has to be 2 witnesses.
Okay.
It doesn't have to be notarized. It's a good idea to have it notarized, but it doesn't have to be notarized. And then the last kind of definition is personal representative. The personal representative, also called the executor, this is the person that you all work with. This is the person that is able to sell the property. This is the person that signs the listing agreement, that signs the contract, that signs all the closing paperwork. So the personal representative is very important. That's the person you all will be working with. Some states use the word executor, but Florida uses the term personal representative. I know it's like super early for this stuff, so thank you guys for being here. So anyways, those are like the most important things, most important definitions that you guys will probably use. So let's see if our newer realtors know. So basically, when someone calls you and says, hey, my friend has a property, they want to sell it, what's one of the first things you would go do?
Who is the owner?
You want to look and find out who the owner is. So you would go to the tax roll, the property appraiser's website to find out who the owner is. And so again, just very basic. The reason you do that is because if John calls you and John says, I have this property to sell, and then you go and you look at it and you see that Julie is the owner, then John doesn't have any right to sell the property. So you always want to make sure that's one of the first steps you'll do, is you want to go on there, on the property appraiser's website to see who the owner is. So, same thing for probate. So one of the easiest ways to find out if you're going to have to go through this court process called probate is to look and see who the owner of the property is. So I gave you all 3 examples. There are 3 different ones. They look like this. But the first one has a property address that says 11309 Southwest 200th Street. See if everybody sees that one. So, who can tell me who the owner of that property is? Maria Pichardo, yeah. So, and then after that, you see the phrase EST and then of. So that means estate of, right? So in this case, Maria died, Maria passed away, and the only way that this property could be sold is to do a probate. I'll wait till everyone gets paperwork. That's all right.
Can you please repeat again about Maria?
Yeah, so after you see the owner, you see Maria Pichardo, EST of, right? So the EST of stands for estate of. And remember we said estate refers to something that somebody owns after they've passed away. So in this case, Maria died. And now the only way that this property could be sold is if you do the probate process. So this is very important for you guys because if you, let's say, Maria has a daughter named Anna, and Anna calls you and she says, "Hey, my mom just died. I'm the only child. She wants me to have the property. I want to sell it." And then you go and you list it. You get a buyer. You go to the closing table, and the title company is going to say you can't close yet because you have to do a probate for what's her name? Maria. Yeah, for Maria. So whenever you see that EST of, it's probably about a 99.9% chance that the property has to go through probate. But this is one of the most simple, the easiest ways that you would know that. Do you have a question?
Yes, I do have a question.
Sure.
This ESD, which stands of course for estate, it is how it appears along with the name. Why it appears with the name?
Good question. So, I don't have the exact answer, but there's the government organization called Vital Statistics, which is for Florida. They're the ones who record death certificates. So when somebody dies, Vital Statistics mails the death certificates to each county, and then the county, I think, looks at the records and will update them. And if they see that the owner has died, they'll put that EST up there to show that she's dead. Sometimes what people do is, and I think this is what happened in this case, her daughter wanted to have the property. And if you're not living in the property, you want to keep getting the homestead exemption, which everyone knows what homestead exemption is basically a tax benefit for your primary residence. And so she wanted to have the homestead exemption. So she went to the county and said, "Hey, my mom died, I want to get the property put in my name." And they said, "No, you've got to hire a probate attorney to go through it." And then they marked her as being dead, as being deceased. And she didn't get the homestead exemption. So if you have clients that they want to keep the homestead exemption, I would not tell them to go ahead and go to the property, to the county and say that someone has died, because they'll probably lose the exemption. That's a little added bonus 2.0, but did that answer your question?
Partially, and also the other question on the first one is what is the will supersedes probate or vice versa?
No. So I'll answer that now since we had another question. So a will, which I talked about, which is just a piece of paper basically, you could do it, an attorney can do it, that says who gets what of your things. The deed supersedes the will. The deed is so if the deed says Anna is the owner, okay, and Maria's the mom, Anna's the daughter, but Maria did a will that says the property goes to her son John, doesn't matter. Anna's going to keep the property. So the deed is more important than the will. All right, so let's look at the next one. 1821 Northwest 33rd Street. And you'll see two names there. One Jesus Silva and one Maida Silva.
It's a nice combination.
Yeah. So in this case, you see Jesus, and then after that, it's EST of, which we know means estate of. So probate would have had to have been done for Jesus. But in this case, Jesus, it was the dad of Maida. Was the dad of Maida. He died. They owned the property together, basically 50-50. So what happened was, Maida, this was an investment property. Maida eventually wanted to sell the property. She gets a realtor. They put on the MLS, they do, and get a contract, everything. 4 or 5 months later, they go to closing, and the title agent says, no, you have to do a probate for Jesus. And she thought, well, my dad, we own the property together. He didn't have any other children. He wasn't married. She thought that she was going to inherit the property automatically. But the way they own the property was, does anyone know tenants in common?
Yes.
Okay, so they own the property as tenants in common, which basically just means they owned it 50-50.
Ownership.
Right. You know a lot for like brand new.
I would pass the state.
Oh, okay.
It happens because she just took the test.
All right, gotcha.
Just have all
It's
the
all fresh in
information
your,
fresh.
it's all fresh in your mind, yeah, okay. So they own the property 50-50, and so they had to do a probate. So this is really common here in Florida, especially South Florida. You'll see where maybe, brothers and sisters own a property, cousins own a property, or even investment partners own a property. And if they only own it as tenants in common, if one of them dies, they'd have to do a probate for the person who died. So fortunately for Maida, she didn't have any other siblings, and she, we did the probate, we got the property 100% in her name, and she sold it. But if she had had other siblings, it wouldn't have been as easy, because the siblings would have inherited his half of the property. So if you see, kind of moral of the story for this one, if you see 2 owners like that, and one of them has EST, again, the estate of, chances are you're going to have to do the probate for the one who's passed away. Any questions on that one?
How long does the process take?
I'll talk on that. That's a part of it. That's okay. Keep you waiting.
So I guess a question would be immediately, have you gone for probate? Are you ready to sell?
Right, because a lot of times people just don't know. A lot of times people don't know. So what I'm kind of trying to show you guys here in the first part is, if you're going to, let's just say, a listing presentation, and you've looked at the property, you see that EST of, you can come to that listing presentation with those questions. With, have you done a probate? Are you going to do a probate? Because a lot of times clients don't know.
Once they go through the probate, does it still say estate of?
No.
Then
Then it's whoever the new owner is.
so if you
So if
see
you look
that
at,
there,
she sold the property, so it would be the new owners. But in this case, this one, the first one, Maria Pichardo, you would see the daughter's name. You would see Annie Pichardo on there now. All right. So how could people avoid this? So how could you avoid having your clients go through the probate process? There's a couple ways. If we look at the last example I gave you all, the 13926 Southwest 161st Court. Okay, so that one, you see Karen S. Rodman, and then after that you see TRS, and then Karen Rodman B. Oh, we got standing room only? This is great. You guys are very excited. We got more seats up here if you want to sit, no worries. Over there. Karen S. Rodman, and then you've got TRS after that. So what the TRS stands for, anyone want to take a guess? Trust. All right. So trust. So a trust is a way to avoid the probate process. So again, it's a legal document, and you can say it's kind of like a will, but a will does not avoid probate. So if you have a will and everything is done correctly, you're still going to have to go through the probate process to get the property in the new owner's name. So again, my example, if I do a will and I have a piece of property and I want my brother to get the property after I pass away, I do a will, it's done properly, he gets the will, I die, he goes to the property appraiser, to the county, to the courthouse and says, look, my brother Justin died, he says I get the property, they're going to say you still have to go through the probate process. So a big kind of misconception out there is that a will avoids probate. Unfortunately, it doesn't. But a trust does. A trust is a different type of legal document that would avoid probate. So in this case, what Karen did, Karen created a trust. She named her daughter, same name, as the beneficiary, and then they changed the deed, which is a very important part of the trust process. So first you do the actual trust, and then you have to do a new deed making the owner of the trust. So when Karen passes away, her daughter automatically inherits the property. She wouldn't have to do the probate process. I know it's like a little complicated, so, or just boring, I'm not sure. But that's a way to avoid probate. Another way you can avoid probate, and this is kind of good information just to give your clients, because they might not know. So if they're not educated about the probate process, you can tell them and say, these are some ways that you could avoid the probate process. Do a trust. You can do another type of deed, which maybe you all are familiar with, the joint tenants with right of survivorship. So it's different than the tenants in common, but a joint tenants with right of survivorship, if you've got two people, if one of them dies, that person's half automatically goes to the other person, and you don't have to do the probate process. So that's a really common way. And another one, just again, a little more complicated, but is a ladybird deed. Has anybody heard of that? Okay, so I'll just tell you because it's super, super cool. Ladybird deed basically is like joint tenants with right of survivorship. But with joint tenants with right of survivorship, if let's say me and you own the property and you want to sell it and I don't, you're probably not going to be able to sell it, even though I would inherit the property, when you pass away and vice versa. Enhanced, a ladybird deed, let's say you own the property, you want me to get the property when you pass away, but you don't want my permission to sell the property, because maybe you want to sell the property to someone. Right. So you could put me on the deed, but you could sell the property without my permission at any given time. But if you keep the property for the rest of your life and then you pass away, the property automatically goes to me. So that's a pretty neat tool for some people who, maybe they want their kids to inherit the property, but they don't want them to be on the deed right now because, you never know if you're going to not get along with your kids later down the road, or maybe they're just going to want to sell the property, right? So you could add them as, do that enhanced life or ladybird deed, put them on there, and then, they'll get it when they die, but they could also sell the property if they want. So another cool, that would avoid probate as well.
So if they are married, do you recommend they do joint tenants with right of survivorship instead of just husband and wife?
Well, they already get it automatically. It's not really called joint tenants with, sometimes they might call it joint tenants with right of survivorship, but married couples, they automatically get the property. So if husband dies, wife gets it. If wife dies, husband gets it. So you don't have to really, it's a certain type of deed, but yeah.
Okay.
Questions up to this point? No? Easy? Okay. All right. So that's that's the easiest way to find out if probate is necessary. So basically look at the titles. Look at what the title says. Find out what's on there. If you think that probate might be necessary, at that point maybe you call your probate attorney or ask your team or whatnot to get more information. But now, assuming that it looks like probate's going to be necessary, what do you do when you go to the actual listing presentation? So again, the point of this is, how many realtors are there in South Florida? Like 50,000, something like crazy, right? So you've got competition out there. There's a lot of competition. But not all realtors are created equal. And so if you go in there and you ask certain questions, you're going to stand out probably from a lot of the competition. Because again, like I said, even in my world, a lot of my clients don't know what probate is, have never heard of the probate process. Even a lot of attorneys who don't do what I do aren't really familiar with what probate is. So you going in there and asking certain questions is going to make you stand out. So there's two main questions that I always recommend to realtors that they ask when you go to that listing presentation. Ask if they have a will, okay? And why do you want to ask that? Well, let's say you're talking to John, okay? John's parents died, and John says, "Yeah, I have a sister, but I think I'm going to get the property. I was really close to my parents and everything like that." You find out that there's a will, and the parents made a will, and in the will it says, "I don't want John to get my property," which is sad and kind of funny, but it happens a lot. Or maybe this specific property, the parents left to their parents or somebody else. So if there's a will, you want to make sure that your client that you're speaking with is included in that will, because otherwise he or she might not be entitled to the property to begin with. So I always, recommend that when you go in there and you're speaking with them, just say, hey, did the person who died, did they have a will? If they say yes, ask them if they can get a copy of it. And the reason is there's no master database that I could go and look for where there was a will. So basically, I could do a will right now, I could give it to him, he could take it, and if I don't tell, my wife, my family, whoever that I did a will, nobody's gonna know that there was a will. So sometimes we'll get a client who calls and they say, oh yeah, I was really close with my brother, I took care of him, he was sick, he told me that I was gonna get everything, I think he put it down in writing, but I can't find it. Well, if we can't find it, then there's not much we can do. So always ask if there was a will, and then ask if there was, if they could find it, or if they have a copy of it. The second question I'd recommend that you guys ask is ask what the relationship was to the person who passed away. So was this their mom? Was this their sister? Was this their, who was it, their grandparent? Who was it that actually passed away? And reason for that question is, if there's a will, we know who's going to get the property. It's probably going to say who's going to inherit that property. If there was not a will, then it means that they died without a will, which means they died intestate, which is another term I don't think we really talked about, but that just means that you passed away without a will. In Florida, there's a hierarchy of who is going to inherit what. So if there's no will, first your spouse would inherit it, then your kids would inherit it, then your parents, then your brothers and sisters, then your grandparents, and it just kind of keeps going out and out. And if you get to the point where you're talking to second and third, Tio, who's way out there, chances are he's probably not going to inherit the property, right? So you want to make sure that you're speaking with somebody who's kind of in the core family. Cousins, aunts and uncles. It's possible that they might inherit the property, but we've got to then find out, well, were there brothers, were there sisters, were there children, anything like that. So again, did you want to make sure that you're speaking with the right person who's the personal representative? Questions on that? You got it all? You guys understand? Okay, good. All right.
I have a question.
Okay, perfect.
You mentioned, of course, that along the way, the husband and wife, and there is by law entirety, right?
Mm-hmm.
It's a definition.
Tenants in entirety, yep,
It's
sure.
entirety, and that supersedes, I assume, all this process, because by law, who survives has a 50%, that's correct? So is that still needed probate, or it is not needed?
If husband and wife, no, you don't need probate.
There you go.
When husband dies, the wife automatically gets it, and you don't need probate,
That's
right?
it.
Yeah, first,
Procedurally.
yeah,
Okay.
yeah.
I have a question.
Mhm.
What if I bought my property years before I get married?
Mhm.
It was I just got married 4 years ago. I want the house for my children, but I get married 4 years ago, so how it works? Do I have to do a?
Is this a real life story?
Yes. Actually, it happens honestly, but I'm thinking about that, because now that you say that, I always say, my house is for my children, but I get married with a guy 4 years ago.
Yeah.
But I bought the property on 1999. So
Well, I'll tell you the answer.
I still want it for my children.
Well, unfortunately, your husband is going to get 50%, and then your children will get the other 50%.
And how can I fix that?
Get divorced.
For me?
Yeah.
Yeah, but I'm asking this because in Colombia, your things are your belongings. If you get married today, all what I get by myself today is going to be mine no matter what.
Yeah. So your main homestead property, you can't give it to your children and not give it to your spouse. So
Doesn't matter that you had it before.
it doesn't matter. Your spouse can choose one of your spouse can choose.
But let me ask you something. Doesn't he get a life estate?
So yeah, I was gonna say there's two options. He gets to choose. He can either have a life estate, which basically means he gets to live in the property until he dies, and then the property automatically goes to your children, and he can't sell it, he can't do anything with it. Or let's say he doesn't want to live in the property. He could choose to have 50% of the property right then and there, and then give 50% to the children, and then they have to decide what they want to do.
Oh my God.
I was under the understanding that anything before the marriage or anything through the marriage towards inherit is separate from the marriage.
No.
That's not.
Unless you have a prenup or something that maybe states something like that. But once it's a part of the marriage, it's a part of the marriage. Now, they might not get everything, so it's kind of complicated, but they would, if, let's say you have, a bunch of bank accounts and all this stuff, the spouse might not get everything. The children from the first marriage or just the children before would still get a percentage, but the spouse could get up to 30% of everything. All right, now we found a topic everyone's interested in. So we got a lot of second marriages and stuff in here.
If you do a trust for the children, and then you get married, then she will be okay with that, or it's still?
So homestead property is Florida law statutes protected. So you can't completely disinherit. You can't completely disinherit a spouse.
Only with a prenup.
Yeah, a prenup is different. I don't do those. I don't know too much about prenups, but yeah, when it comes to as far as what inheritance is, you can't completely disinherit a spouse. They're entitled to up to 30% of the total estate apart from the homestead property. So if anyone's thinking about getting, yeah.
It might look like an accident.
All right. That was recorded, so I don't know.
Oh my God.
You have a question?
She's all depressed now.
No.
Sorry.
How about the couples that they are not married, but they've been for 20 years or something?
Yeah, there's no common law marriage. So if they're not married, it's as if they weren't entitled to anything.
What's that?
If you're not actually married, if it's just, maybe you have a life partner, someone you've lived with for 15, 20 years, if you were to die, he or she would not get anything. Unless you did a will or a trust or something.
There are no steps to take before someone gets married to prevent that in the future?
The prenup.
Other than the prenup?
Well,
That lady bird thing with the kids?
yes, but again, you can't disinherit your spouse. So
No
even
matter what you do, if you got married 10 years after,
Yep.
he has these.
Yeah. Okay, so shifting a little bit back to, so that's you want to make sure you're speaking with the right person. So you want to make sure, find out what the relationship was. Now, again, so the reason for all of those questions is because, like I said in the very beginning, the personal representative, that's the person who gets to sell the property. And so if you're not working with a personal representative, you're kind of, wasting your time. So the personal representative, one thing to note, a person does not become the personal representative until the court says they are. So you're going to get a piece of paper, or we're going to get a piece of paper and give it to you that says, John Smith is now appointed personal representative. And that's when that officially takes place. If he has a will, and the will just says John is the personal representative, that's not good enough. Because we've got to present that will to the court until the court and the judge is going to sign a piece of paper saying that he's the personal representative. Okay? Once we have that, it's called an order appointing personal representative. Once we have that, you all can go ahead and start marketing to sell the property, list the property, and all of that. So, is everyone hot?
Yes.
Very good. Well, let's just set that up.
Thank you.
Yeah. Oh gosh. So Alright, so the personal representative, that's the person who's signing the listing agreement. That's the person who's signing the contract. So very, 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 very important. You cannot list a property with someone until you have that order appointing personal representative. Like that first example, or second example I gave you with Maida and Jesus, where the realtor listed the property but didn't do the probate for Jesus. Big no-no. I mean, she didn't get in trouble, but you can't do that because only the personal representative has the authority to sign anything. So again, we get that piece of paper from the court. Once we have that, now you can list the property, you can market the property. The personal representative is the person who's going to sign the contract. I always recommend have the person sign it as personal representative. So let's say John is the personal representative. Whenever he signs that the as-is contract, the listing agreement, any sort of, anything that he's selling for the real estate itself, have him sign it John Smith as the personal representative. Clear on that?
Like a legal power,
What's that?
like a power attorney.
Yeah, it's sort of like a power of attorney.
For how long
It's
does the court appoint you to be the personal representative?
until the process is over.
So you cannot expire on a
No, they want the probates to finish within a certain amount of time, but you could really, we have some that are very old and they're still the personal representative, so they can last a long time. What else on that? All right, so how long does the probate process take? Right, so that's a big question we get. Probate has kind of a reputation of taking a long time, and it can. There's really two different types of scenarios. The first scenario is if the person died more than 2 years ago. So let's say the person died in 2015 and we're starting the probate process right now. So it takes about 30 days to have the personal representative appointed. So from the day that the client signs everything, you open the case with the court. So about 30 days, now the personal representative is appointed. So that's month 1. Month 2, now that you've got the personal representative appointed, you can go ahead and sell, list, market, do everything with the property. So if it's more than 2 years from when you start the probate, it's going to be about a 2 to 3 month process. Okay? If the person passed away more recently, so if someone died in 2018 and we opened the probate in 2019, it's going to be a little bit longer. So again, we're going to have about 30 days to get the personal representative appointed, and then month 2, month 3, and month 4, we have to wait. And so we're waiting because there's a mandatory, what's called a creditor period. So let's say John died and he owed money to Baptist Hospital, he owed money to Visa, to American Express or whatever. They have 90 days to basically come to us, the attorneys, and say, hey, John owed us money, where's our money? And then we fight with them to reduce those claims or whatever. After that 90 days is up, so that'd be month 1, 2, 3, 4. So around month 5, then you all can go ahead and sell the property. Because most of the time, while we're waiting during that 90 days, the judge, the court is not going to let you all sell the property. You could still list it, you could still go under contract, but as far as actually closing, it's probably going to be, until month 5. Questions on that? So there are a couple exceptions. So let's say, it happens fairly often where someone passes away and now who's paying the mortgage? Who's paying the HOA dues? Who's paying all the bills and everything like that? Well, hopefully the kids or hopefully someone's able to, but if not, the property may go into foreclosure or there's a tax lien or whatever the case may be. So what I always tell, we can try, we can go to the judge and we can say, hey, look, judge, if we don't sell this property right now, the family is going to lose it. And sometimes the court will allow that. Sometimes the court will say, okay, you can sell it. We put that money into a restricted account, kind of similar to an escrow account. You all get your money, you get your commission, and then at the end of that 90 days, then we can release the money to the seller. So sometimes if there's like a circumstance like that where you might lose the property, then we can ask the judge to sell the property a little bit sooner.
Are they usually lenient?
It depends. It really depends. We have probates in 17 counties throughout Florida right now, and some judges yes and some judges no. It really depends. All right, and then I always get asked about costs, so that's another thing we get asked a lot about for probate costs. I would say there's really 3 ways that most attorneys will charge, they're either gonna charge hourly, which hourly is basically, you call me, I'm charging you for that. You send me an email, I'm charging you for that. They'll charge a flat fee, which is, one price for the entire thing, or they may charge a percentage. So by law, they can charge up to 3% of the size of the estate. We generally do flat fee, but the price itself really ranges, I would say, on, the lower end, probably 4,000, on the higher end, probably 10,000, somewhere in that range. But it depends on, if you've got siblings fighting, if you've got 3 wills that we're trying to do, if you've got a bunch of people in different countries who are fighting, sometimes that can make it, the price go up and make it a little bit longer as well. But that's, kind of a ballpark figure. But I always say, it's probably not a good idea to recommend price to the client, because it's kind of like if I say, hey, I've got a realtor for you, and then I say, hey, she'll do it for 1%, and then you go in there, you're probably going to be pretty pissed at me, when I say 1%. So just, that's just kind of for you guys to have an idea more or less of what the price is. All right, so then lastly, how can you guys find probate listings? I think this is a good market. There's, again, in South Florida, there's it's an older population. Chances are you're going to come across a probate listing at some point. So hopefully you can take some of this information and use it. But you can also market specifically for probate. There's a couple ways. For one, if you go to the property appraiser's website, in the owner box, how you can search by owner, if you put a state of, and you just hit search, and you just search by the state of, you're going to get a lot of properties that are owned by estates. You got their name, you got the address, and you could do direct mail to them, door knock directly to them, and try to get listings that way. One thing I always say though, this is not just like any other transaction where, hey, we can help you find a buyer, cash buyer, quick, close in 10 days, whatever. Someone's passed away, so it's a little bit more of a sensitive subject. So you want to go in there with a little bit more compassion on the terms of, hey, I'm sorry for your loss. I know this might be a difficult time for you. We can help you, that sort of thing. But you can find addresses of estates by doing that. So if you go to the property appraiser website, and then in the owner box, how you can search by owner, if you just put estate of, so ESTATE of, you can find listings that way. So you're going to get like a list of, I do it every once in a while, and it's between 100 and 200 different names and addresses, and then you could, if you have direct mail, you send them door hangers or door knocking or however you want to approach it that way. There are also lists that you can buy. You can go to public records and you can find, in Miami-Dade.
By the time that the deed already said state, that means that the person already died, the court already got into it, and then they changed the deed, and that's how you buy it?
It just means that it could be that a probate is open, but in my experience, it just means that the person has died. Because remember in the beginning I said sometimes the county gets notified when people pass away, and then they just update the deed. They just update themselves. It doesn't mean that a probate has been opened yet. So they still.
As soon as somebody gets deceased, the county gets informed, and as soon as the deed gets changed to a state automatically.
Sometimes yes, sometimes no. Sometimes there's really no rhyme or reason to it. Sometimes it does take a little while, or sometimes, again, in the example I said, if a daughter is inheriting the property and she goes to the county and maybe she says, hey, my mom died yesterday, can I get the property in my name? Now the county is going to change it and say, oh, well, it's owned by your mom, the estate of. And then that would show up when you did your search. So I can't tell you every time at what stage it is. I just know that if you see a state on there, it's either in the process of being a probate or it's got to go through the process of being in probate. One other way, you can go to the county records. You can buy the list as well, but you can go through the county records as well. And in every probate that we file, it has the attorney's name, and it has the personal representative's name, and their address as well. So you can get that information, and again, you can do. Does anyone do door knocking? Does anyone? No? There we go. I think door knocking is a great thing. Door knocking, mailers. Does anyone do mailers? All right, how's everyone getting their business? Just networking, referrals, Zillow, all of that. Mailers. I don't know what mailers are. Yeah, but you can get the addresses directly. Again, I think this is like a good supplemental practice because there's not a whole lot of people actively going for them. And so if you go to, start marketing yourself as like the probate expert and you're getting information, it's a pretty good way to kind of build like a supplemental practice. Also, again, other probate attorneys, not just myself, but other probate attorneys can be good referral sources as well. Because again, like I said, we have about 150 or so active probates in our office. Most of them have a piece of real estate. So we're always, kind of referring out, business to realtors as well. So probably other probate attorneys are potential good referral sources for you guys.
So the process is to reach out to the person and then contact you in order to okay.
Sometimes people reach out directly to the personal representative. So like I said, if we get a case, we file the case and we have to put the personal representative's information, that's public record, and then you guys are able to get his or her information, maybe you contact them, and then my client will call me and say, hey Justin, I found a realtor I want to use. I say, okay, great. And that might have been, you sending a mailer, door knocking, or, calling, whatever. So that's a way. Yeah? All right. Well, if there are, yeah, okay, go ahead.
Require an appraisal for the probate to go through?
Is it what?
Does it require an appraisal or just comes by a realtor?
Not usually appraisal. No. Yeah, comps are usually enough. So if there's, what's that? If there's fighting siblings, like if, let's say the personal representative hires you to be the realtor, and then there's his brother really doesn't like you or doesn't like whatever the case may be, and they're saying your price is way off, maybe we have to do an appraisal, but I would say 9 times out of 10, we just take the comps and that's all we need. Yeah.
And the personal representative has the authority to sign the agreement 100%?
100%, yeah.
Alright.
Yeah, that's the person you want to work with, because otherwise, there's not much you can do. Because it's the personal representative who gets to choose the realtor.
The daughter or son or whatever would never be the personal representative, or do they get appointed as personal representative?
The daughter's
Is it a third person?
No. It's usually the son or daughter.
Oh.
It's not a third person. It's usually a family member. Yeah, 9 times out of 10 it's a family member. Yeah. Okay. Well, no other questions. Thank you guys so much. I'll stick around for a little bit. And yeah, so if you did sign in, and I'm going to circulate this video so that if you have any, want to watch it again, you can. But my information is on the back. If you want, drop your card, and I'll send you some, free resources and stuff that we have as well. And thank you all. Appreciate it.
Thank you.